When foreign investors draft a shareholders agreement in Vietnam, the document can appear comprehensive and detailed. It may cover multiple aspects of the business relationship. But in reality, not all clauses carry the same importance. Certain key clauses determine whether your investment is protected or exposed. Without these critical provisions, your shareholders agreement in Vietnam may exist, but it may not protect your control. A shareholders agreement in Vietnam is a private legal contract that defines how investors interact within a company. While Vietnam company law provides a basic framework, it does not automatically include all protections foreign investors expect. This means that your level of control depends on how well specific clauses are drafted. Understanding what to include in a shareholders agreement in Vietnam is essential for reducing legal risks. Voting rights are one of the most important clauses in any shareholders agreement in Vietnam. They determine how decisions are approved and who has authority. Without clearly defined voting thresholds, foreign investors may find that their influence does not match their ownership. Even majority shareholders can lose control if voting rights are not properly structured. Reserved matters are decisions that require approval from specific shareholders. These may include capital increases, major investments, or changes in business direction. A well-drafted shareholders agreement in Vietnam must clearly define these matters. Without them, critical decisions can be made without your consent, creating significant risk for foreign investors. Another key clause involves the structure of the board and management authority. A shareholders agreement in Vietnam should define how directors are appointed, how decisions are made at the board level, and what authority management holds. Without these provisions, foreign investors may lack control over daily operations, even if they hold significant ownership. Exit clauses are essential in any shareholders agreement in Vietnam. Provisions such as tag-along rights, drag-along rights, and share transfer conditions ensure that investors can exit under fair and predictable terms. Without these clauses, foreign investors may be locked into the company or forced to exit under unfavorable conditions. Profit distribution is another critical aspect that must be clearly defined. A shareholders agreement in Vietnam should specify how and when dividends are distributed. Without clear provisions, disputes may arise regarding profit allocation, especially when investors have different expectations. Disputes are inevitable in any business relationship. A strong shareholders agreement in Vietnam must include clear dispute resolution mechanisms. These may involve negotiation procedures, escalation steps, or arbitration. Without structured mechanisms, disputes can escalate and disrupt business operations. Even the strongest shareholders agreement may not be effective if it is not aligned with the company charter in Vietnam. The charter is the official document recognized by authorities. If there is a conflict between the two, enforcement becomes uncertain. This makes alignment between documents a critical part of legal structuring. At LTS Law, we provide legal services for foreign investors in Vietnam by drafting and reviewing shareholders agreements that include all critical clauses and align with Vietnam company law. We ensure that your agreement is not only comprehensive but also enforceable in practice. Before investing in Vietnam, visit lts.com.vn and consult with our legal team to ensure your shareholders agreement is structured to protect your control and long-term interests.